Thank you so much, Ian, for that really nice introduction. And I'm so happy to be here among so many friends from all kinds of different walks of life, from the Biden administration, from the administrative law, professor world, so many former students who are now environmental law and policy leaders. It's really a great day, and I'm delighted to kind of be back, reconnected with my policy integrity colleagues here at the law school. So my talk today will focus, the title is New Challenges for Federal Regulations, Executive Branch Responses. So in the last decade, and this has been discussed in the morning panels, federal regulations, and particularly federal environmental regulations, have faced additional hurdles. First, the Supreme Court became less sympathetic. Loper Bright and West Virginia versus EPA have gotten the most attention, but I view Ohio versus EPA and Michigan versus EPA as being part of the same phenomenon. Now, two other hurdles faced by regulations over the last decade are not related to jurisprudential moves by the Supreme Court, but by the increasing polarization of the political parties. In particular, state attorneys general of the party opposing the president have become aggressive litigants, often filing cases before sympathetic judges in single-judge divisions or judicial districts. Actually, this goes on only on one side of the attacks, not on the other. But state attorneys general of both parties have been filing these actions aggressively. And judges have often granted nationwide injunctions against challenged rules. And also, incoming administrations have begun using a variety of tools to attempt to undo the regulatory output of predecessors of the opposite party. And both of these political phenomena are fairly recent. AGs often had challenged federal regulations in the past, but this became like a real thing and a concerted effort during the Obama administration, mostly during the second term of the Obama administration, done by Republican attorneys general, and continued in the Trump administration, done by Democratic attorneys general, and in the Biden administration by the Republicans, and you get the picture. Democratic attorneys general are busy now. And the undoing of past administration regulatory outputs is also a fairly recent phenomenon. When the Obama administration came into office, I'm sure there were a lot of policy disagreements with things the Bush administration had done, but it wasn't like an organizing principle of the incoming administration to try to undo as many of them as possible. It was different when the Trump administration came into office. Big flurry of CRA, disapprovals, big flurry of interventions in pending litigation, placing cases in abeyances, also suspending effective dates of rules, doing so aggressively. That was the first time it had done. And actually, the Biden administration was the first Democratic administration to actually invoke the CRA, and now this is CRA season, and we're seeing a fair amount of activity and may see quite a bit more over the coming weeks. So these are basically phenomena that started within the last 10 years. It wasn't always this way. Same for the court. The cases I mentioned are roughly cases decided in the last decade. Now, in the paper on which this talk is based, largely through empirical work, I'll explore how administrative agencies have responded to the challenges caused by less sympathetic courts and increased political polarization. Agencies, thankfully, did not just keep doing what they had done before and thereby resigning themselves to worse outcomes. Instead, the executive branch has responded to these challenges, particularly beginning in 2023 and accelerating in 2024 in ways designed to increase the resilience of their regulations. So first, I'll examine the efforts to conclude on priority rules earlier in the last year of the president's term that had previously been the case, thereby shielding them from hostile actions by an incoming administration, not only CRA disapprovals, but also the shenanigans that can happen in litigation when a new administration takes office. Second, I'll discuss the far more robust use of severability as a tool to protect portions of regulations, even if other portions are struck down. And third, I'll explain the significantly enhanced efforts that agencies have undertaken to discuss the regulatory antecedents for their actions as a way to be in a better litigation position following Loper-Bright and West Virginia versus EPA. So on timing, perhaps the most important way that an administration can protect itself from the undoing of its rules during a subsequent administration is by not waiting too late in the president's term before finalizing them. In this connection, congressional disapproval under the CRA has gotten the most attention. So I think all of you know, under the CRA, a rule finalized during the last 60 legislative days can be disapproved by the subsequent Congress under fast-track procedures that, most importantly, bypass the filibuster rule that would otherwise apply in the Senate. As a result, regulations can be disapproved by a simple majority vote in the Senate, as opposed to the 60 votes that otherwise would be needed to advance a bill. Typically, this mechanism works only if a presidency changes party hands and if the incoming president's party also controls both the House and the Senate. Absent unified congressional control, resolutions of disapproval will be unlikely to pass. And absent the president aligned with the congressional majorities in both chambers, the president would veto such a resolution. And given the relatively close balance of seats in Congress in recent decades, a veto of that sort will be unlikely to be overridden. But in recent history, incoming presidential administrations faced unified government when they took office, and thus CRA disapproval is a real possibility that administrations must contend with. Indeed, the last instance of a president taking office with a Congress of the opposite party was in 1989 with President George H.W. Bush. Now, after 2 years, the situation is different, but the CRA doesn't matter at that point. Presidents often lose congressional majorities after the midterms. Now, there are many other reasons why early conclusion increases the regulation's resilience, in addition to the CRA. In particular, a rule is more likely to survive judicial scrutiny if the administration that promulgated it gets to defend it in court before leaving office, or at least gets to participate in as many stages of litigation as possible. It's also the case that even if a rule is completed too late to protect it from CRA disapproval or to defend it in court, there is value in ensuring that its effective date occurs before the end of the administration, although I won't address that in this talk. It's addressed in the essay, and if you're interested in this issue, you can read about it. So, April push. So in light of the significant benefits in not waiting until too close to the end of the presidential term to complete priority regulations, the Biden administration undertook a successful and actually unprecedented effort to do so earlier than had been the norm. The earlier completion of Biden administration's priority regulation was actually made possible in part by the leadership by agency exerted. As you know, we are responsible for managing the regulatory process for executive branch agencies. And I had the privilege of leading it during the period in question. So every administration going back to 2001, maybe earlier, but I only looked at this through as back as 2001, concluded a review on a disproportionate number of rules during the last year of a presidential term. So more rules get done in the president's last year than each of the previous 3 years. The proportion for the last year ranged from 29% for the second term of the Bush administration, which is more than 25%, and 51% for the Trump administration. The Trump administration is actually an outlier in doing hugely disproportionate number of rules in its last year. But on this score, the pattern is reasonably similar across the three administrations I looked at: Bush, Obama. The four administrations I looked at: Bush, Obama, Trump, and Trump, and Biden. But in the prior administrations, the last year rules were mostly done during the last 4 months of the president's last year, sort of between October 1 and Inauguration Day. This is kind of a bad time for the CRA. In contrast, in the Biden administration, they were done during the first 4 months, January through April. And the differences are stark. For Bush, Obama, and Trump, those administrations concluded review on their last year rules in the first 4 months, only in 22, 17, and 19% of their last year rules. So they were actually pretty similar. So Bush, Obama, and Trump had pretty similar patterns, not very many, not a high proportion of last year rules concluded in the first 4 months. In contrast, the Biden administration concluded review on 52% of its last year rules during the first 4 months. It was a very, very stark difference. Now, the effort to conclude review and regulations by the end of April was not just a noteworthy statistic. The output that month includes some of the Biden administration's most significant regulatory priorities, particularly with respect to environmental and climate change rules. For example, the 10 EPA rules on which OIRA concluded review in April, and all of which were actually published in the Federal Register by May 13th, very quickly, included 4 important rules regulating the emissions of a range of pollutants from power plants, limiting their greenhouse gas emissions, emissions of hazardous air pollutants, discharges into navigable waters, and disposal of coal ash. Also included in those 10 rules were 2 key rules under the Toxic Substances Control Act, one setting forth procedures for chemical risk evaluation, and the other limiting methylene chloride, as well as a rule limiting the emissions of hazardous air pollutants from copper smelters. And one designated PFAS, which are forever chemicals, as hazardous substances under the Comprehensive Environmental Response Compensation Liability Act. By acting early in comparison to historical standards, the Biden administration significantly added to the resilience of the regulations reflected in reflecting its key priorities. In particular, by the end of April 2024, the Biden administration concluded review on its 2 most important climate change priorities. The rule limiting the greenhouse gas emissions of power plants, which I just mentioned. And in the run-up to April, in March, OIRA did the concluded review on EPA's vehicle emission standards, which also produced significant greenhouse gas reductions. And also in those first 4 months, OIRA did the EPA's National Ambient Air Quality Standards for particulate matter. It's a rule with enormous public health consequences, predicted to avoid per year 4,500 premature deaths, 800,000 cases of asthma symptoms, and 290 avoided workdays. And the list continues. Also in March, right, kind of before this run-up to April, EPA set the first ever PFAS regulations for drinking water. So it turns out that for the Biden regulations, the look-back period under the CRA actually began on August 16th. I mean, this is a difficult situation because you actually don't know when it's going to be until it's too late to do anything about it. And as a result, the Biden administration was able to protect all the rules for which it concluded review in April and in all earlier months from CRA disapproval. Now, you might wonder why was such a big cushion needed? Well, because OIRA concluding review is not actually a relevant thing. The relevant thing is when the agency head signs a rule, which typically takes place within days, but then the rule has to be published in the Federal Register, which can be a cumbersome and very long process. And also, it needs to be properly submitted to Congress, which would seem like a ministerial thing, but it actually is extremely complicated as well. On the Federal Register, I mean, one of the worries I had going into this period is that there was one rule, the methane rule. There was a rule limiting the methane emissions of oil and gas installations, on which we concluded review in November of 23. It was a centerpiece of the administration's plan for COP, for the Conference of the Parties that year, which was like in early December. So it had to get done. It's enormous pressure. And then the rule wasn't published in the Federal Register until March. So more than 3 months had gone by. And I began to really worry that this part of the problem was going to basically kill all of our efforts, and it was going to become like a Federal Register problem. We took some significant action both in giving guidance to agencies and also trying to better manage the process, which actually illustrates some of the benefits of having a kind of robust centralized review system. Congressional submission, I mean, this is something actually, believe it or not, I think nobody in the executive branch really understood well before a bunch of us actually, there's a lot of people in this room, got involved in this. But it's very complicated because, in part, because they're sticklers for detail. So if, for example, the Senate requires wet signatures. If you don't submit a wet signature, it gets sent back, and so the Senate clerk sends it to whoever email address they happen to have. That person might have left the agency decades earlier, and so no one finds out about it, and so you can't really resubmit it. And so you have to track this stuff. But more importantly, the parliamentarian has a ruling that the relevant date, even though the statute says submission, is when the rule is referred to a committee and when the referral to the committee is published in the congressional record. And apparently, referrals to committee can't happen when the Senate just has pro forma sessions. It needs to actually, Senate every week has 2 days of pro forma sessions, essentially to prevent recess appointments by the executive branch. But nothing happens in those pro forma sessions. Session is open, it's closed within 30 seconds. During that period, things cannot be referred to committee, even though the referral to committee isn't done by senators. And in an election year, which are the relevant ones for these purposes, the Senate takes between 5 and 7 weeks off during the summer. So if you don't hit it at the beginning, before the beginning of this period, you hit it too late for the CRA. So that's kind of another thing to worry about. Turned out, we protected the last of our rules on August 2nd. So we actually had a 2-week cushion, but the congressional calendar that had been published at the beginning of the year had the CRA window starting on August 1st. It turned out that at the end of the session, the Senate added a bunch of extra days, and that kind of extended the beginning of the look-back period. So actually, we sort of guessed right. I mean, if the Senate had actually stuck to its calendar, one of our rules, one of the 81 rules we did in April, would have ended up on the kind of disapproval within the look-back period. So as I said, the CRA got most of attention. It's not the only reason for agencies not to wait too late in an administration's last year to complete review. It's hugely important for the administration that promulgated the rules to handle litigation challenges, at least for as much of the litigation as is possible. Obviously, the litigation strategy is then likely to be best aligned with an administration's policy decisions. There will be the case if an administration is actually hostile to the rule, gets called in to defend it, which obviously it might not. So if the judicial review hasn't happened by the end of the administration, a subsequent administration is very likely not to defend it at all. During the most recent presidential transition and the 2 prior ones, the incoming administration, so both parties have done this, the incoming administration asked courts to hold pending challenges in abeyance while they consider whether to repeal or amend the rules. And doing so is advantageous for an incoming administration, in part because it permits to reconsider the regulation without the possibility of an intervening judicial decision upholding the rule, which would make reconsideration more difficult, especially if the administration is out there to argue that the rule is unlawful and that's why it needs to do it. It's kind of like that argument is significantly undermined if the court just said, this is actually all fine. And courts have been very liberal granting abeyances, again, on kind of in transitions of both parties. Also, in cases where a lower court struck down a rule, an unsympathetic subsequent administration would decide not to pursue an appeal, thereby leading to a court's vacatur. Or even if a subsequent administration continues to defend the rule promulgated by its predecessor, and there's one instance of the Trump administration actually doing it now, it might not make certain arguments if they're inconsistent with its policy preference. So you won't get the same robust defense that you'd have gotten if the promulgating administration had done it. And there are tools beyond abeyances. The executive actually asks for vacatur of the rule while it reconsiders it. It could enter into sort of a collusive settlement with sympathetic parties, and that can work if there are no interveners. So there are many tools that can be used, and they've all been used in one way or another at some point. So this made a difference. So for example, by concluding review in April, the Biden administration successfully got to litigate the stay requests for some of EPA's most significant regulations. And most importantly, during 2024, the DC Circuit, which is where many of the important environmental rules of nationwide application have to be challenged, and then also in the Supreme Court, the courts denied stays on 4 important rules discussed above. So the Supreme Court denied stays. So stays were denied on 3 of EPA's power plant rules, as well as on the methane rule. And these were hugely important administration priorities. And the DC Circuit denied stays on 3 other rules. And for those rules, Supreme Court stays were not sought. The denial of a stay on the EPA rule limiting the greenhouse gas emissions of power plants is particularly significant because the court had granted a stay on the Clean Power Plan, which was the Obama administration's predecessor. And the court was actually less hostile to environmental regulations at that time than it had become by 2024. Victories in the stay applications matter because absent a stay, the clock towards the rule's compliance deadline continues to tick. And as that happens, regulated community is more likely to make durable investment decisions to come into compliance, thus effectuating the rule's purpose, even if the litigation ultimately doesn't get resolved favorably. Also, the merits argument in the DC Circuit and the challenge to the EPA rule limiting the greenhouse gas emissions of power plants took place on December 6, 2024. So the Biden administration got to both brief and argue the case. And 10 days later, the DC Circuit heard argument in the challenge to EPA's tightened national ambient air quality standards for a particular matter. But the oral argument on other priority rules did not get to take place in the Biden administration. We sort of despite all these efforts, we didn't do this early enough. And most importantly, at the end of the Biden administration, the DC Circuit had not decided the challenges to any of the environmental regulations for which OIRA had concluded review in April of 2024. And predictably, the Trump administration sought abeyances in several pending cases, and also consistent with prior practice, the DC Circuit granted abeyances in many of them. For example, the court granted abeyances in the challenge to EPA's limits on the greenhouse gas emissions of power plants and on the emissions of hazardous air pollutants by power plants, and also granted an abeyance on the hugely important national ambient air quality standards in particular matter. So in summary, despite the unprecedented efforts to conclude review on priority regulations earlier in the president's last year, the full benefits with respect to litigation over challenges to these rules were not reaped. We got the benefits on the CRA front. We got some partial benefits on litigation, but far from the full benefits. And one of the, I think, challenges is how to have that happen in the future. It turns out that to fully accomplish the goal of completed litigation over challenges to priority rules, these rules need to be completed significantly before April of the last year of a presidential term, which is what we did. Indeed, in the DC Circuit, the median time from the filing of a petition of review is about a year, so you would need more time. And also it takes 60 days until a petition of review needs to be filed. So that basically means kind of 14 months you'd expect from the time a rule is published in the Federal Register, which is also after the rule is signed and after OIRA concludes review for a DC Circuit decision. That means that actually for half the regulations it takes longer, and also these statistics don't include the time for possible Supreme Court review, when an incoming administration can also try to undo the work of a prior administration simply by not seeking cert from an adverse decision below. So to have a reasonable probability of completing the judicial review process on prior rules by the end of an administration, the rules will need to be promulgated in the third year of the administration, not its fourth year. And because of the time it takes to promulgate complex rules, the regulatory calendar is actually very punishing for a one-term president. Historically, for such rules, it's taken 2 years of work to publish a proposed rule, and a year and a half of additional work to publish a final rule. So if you do the math, 2 plus 1.5 is 3.5, and then like a little over a year for the DC Circuit review, and like sometimes the Supreme Court review. This is now way over a president's term. The Biden administration did better than had previously been the case on the proposed to final period. For example, for the EPA rules on which OIRA concluded review in April of 2024, which were unusually long and complex rules, the median time from proposal to final was around a year, which means that 6 months have been shaved relative to historical studies, which is significant. But while that accomplishment is noteworthy, the time frame from taking office to publishing priority proposed rules would need to be shortened as well. And the most likely candidate for a significant improvement in this area is better use of the presidential transition process. Under the Presidential Transition Act, each of the major party candidates gets resources to begin to shape its plans several months before the election. During the last 2 transitions, so the incoming Trump administration, the incoming Biden administration, the incoming Trump second term, incoming administrations used this time to prepare a voluminous package of executive orders that were issued the first day and the first week of the new administration. These executive orders typically give direction to agencies to reconsider the prior administration's regulations. But in the future, incoming administrations should also use this time to make basic policy decisions around what the replacement regulations would look like. There are, to be sure, limitations about how much can be accomplished during this period. Drafting work would probably not start until the administration took office and had access to agency career staff, where a great deal of the government's scientific and economic expertise resides. But making the priority decisions during the transition, the priority policy decisions, would undoubtedly lead to quicker drafting once the president takes office. Now, I don't want to minimize the difficulties here. It would not be an easy task. And for starters, it would require a far more robust transition operation than had previously been the case. And most importantly, it would require a transition team with the authority to make policy decisions. Because if basically, proposals come up in the transition and then the incoming officials ignore them, then you don't get the benefit of this work. So it would basically involve a significant change in the way that transitions are structured and authority is delegated. And, it could happen, it might not. Okay, so that was timing. Severability and antecedents, these are 2 things designed to put rules in better positions against a hostile judiciary. So one important way in which agents have responded to this more challenging judicial landscape has been by significantly increasing their efforts to ensure that judicial decisions striking down one portion of a regulation is not fatal for the whole rule. The relevant legal inquiry in this context is whether the portion of the rule struck down by the court is severable from the rest of the rule. If it is severable, the rest of the rule survives. If not, the whole rule is struck down. Agencies can put themselves in the best position to have the regulations found to be severable by adopting 4 best practices. First, an explicit discussion of severability in the regulatory materials, in the preamble or regulatory text, increases the probability the first prong used by the courts, intent, agency intent for the rule to be severable, for that to be satisfied. Second, robust discussion in the preamble about why portions of the rule should survive, even if others fail, makes it more likely that the second prong of the judicial test, workability, is satisfied. Third, discussion in the proposed rule, as opposed to doing it so at the beginning of the final rule, allows for public comment on severability that can be used to support and generate arguments for severability. And also, if comments are not filed on particular assertions, those will be waived for judicial review. And fourth, an explicit mention in the regulatory text, as opposed to only in the preamble, makes it more, basically ensures that there wouldn't be arguments about how there wasn't sufficient notice to parties to comment because it was just a sentence buried in a 1,000-page document. In the last 2 years of the Biden administration, the annual number of regulations published in the Federal Register that mention severability or several provisions drastically increased. In 2023 and 2024, respectively, there were such mentions in 147 and 327 published regulations. In contrast, for the period in 2001 and 2022, so the prior 22 years, the mean was 26 and the median was 24. So basically, by 2024, the number was sort of like 12 times what the average for the prior 22 years had been. And the pattern for significant regulations, which are ones that are wide reviews, is actually similar to the overall pattern. Same sharp increases observed in the regulatory text. Agencies included significantly more codified severability clauses in the regulatory text of the regulation in the last 2 years of the Biden administration than in any of the previous 22 years. In 2023, there were 73 published regulations that contained severability clauses in the regulatory text, and there were 115 in 2024. Comparison, a mean of 16 and a median of 12 over the prior 22 years. Also, more robust discussion about why portions of a rule should survive, even other portions should be struck down, makes a big difference. And I won't bore you with all the statistics, but Westlaw has this neat thing called snippets, which are references don't appear within 20 words of one another, so it kind of shows that this concept is used several times. The number of snippets for each reference to severability in a rule increased dramatically during this period as well. Okay, regulatory antecedents, the last thing. As in the case of severability, agencies have significantly expanded their reliance on regulatory antecedents. In West Virginia versus EPA, as was already discussed this morning, the Supreme Court struck down the Clean Power Plan, claiming that the agency had discovered in a long extant statute an unheralded power that represented a transformative expansion of its regulatory authority. And as a result, it struck down the regulation. So long extant statute, unheralded power, transformative expansion. These terms were actually not original to West Virginia versus EPA. In fact, in the case, the court quotes the use of these terms, and in this case, those of us in the environmental law field refer to as UARG, which was decided in 2013. So whether the power an agency asserts is unheralded depends exclusively on whether the regulation has antecedents. If the agency has done something like this all the time, then presumably the power is not unheralded. The more robust the antecedents, the less unheralded the power. So the relevant inquiry therefore revolves around whether the agency action constitutes a marked and substantial departure from actions the agency has taken before. And Loper-Bright reinforces this. The Supreme Court repeatedly explains that two factors make it more likely for statutory interpretations of administrative agencies to be accorded respect. The interpretation be issued roughly contemporaneously with the enactment of the statute, and that it remain consistent over time. That is, that it have antecedents. And when both factors appear together, the respect accorded to agency interpretations apparently is even greater. The court shows that these principles have long historical pedigree, spanning 2 centuries. There's lots of quotes from very old cases. And in the ghost gun case that Tom Merrill mentioned this morning, the court reinforced this reference to the importance of antecedents. And again, in the interest of time, I won't bore you with the statistics. huge increase. And in particular, the terms unheralded power, long extant statute, and transformative impact, which agencies should have really started using after UARG, which was the 2013 case. They virtually didn't use it all between UARG and essentially West Virginia versus EPA, but then started using far more frequently after West Virginia versus EPA, suggesting that, again, something changed in 2023. So the executive branch has definitely made efforts to put itself in a better position. Now, to conclude, the timing definitely affects the resilience of regulations. That's kind of indisputable. I mean, for one thing, if you're not in the Congressional Review Act window, I mean, you're just not there. And if you can finish the litigation or as far, done as many steps as possible, you've actually done them. Now, cynics might wonder whether measures undertaken to make rules more resilient to legal challenges will end up having their intended effect, given the general hostility, of course, to regulation. I've been in conversation with people who say, well, this is not going to make any difference. I'll just find some other reason to strike down your rule. And actually, I'm not sympathetic to those criticisms. I'm actually not a cynic in this way. So in this connection, the poor record of the first Trump administration in defending its deregulatory measures in court, even late in its term, when the composition of the judiciary was most favorable because of its many judicial appointments, should provide some solace. As should the fact that the Supreme Court, even with close to its full complement of Trump-appointed justices, dealt the Trump administration a significant blow in the census case, very, pretty late in its term. Justice Barrett hadn't joined the court yet, but the other two appointees had. I'm going to now give you, so everyone sort of has followed this, but I'm going to give you an idiosyncratic example that I happen to like. So I mentioned Michigan versus EPA. So this was a case in which Justice Scalia held that, basically struck down the Obama administration's determination of the regulation of the hazardous waste emissions of power plants was appropriate and necessary. These were the statutory terms, because the agency hadn't considered costs. In the process of saying this, Justice Scalia also cast various aspersions of how the agency had considered benefits and suggested that the costs far outweighed the benefits, even though this was actually factually not the case, but he played around with what he counted and what he didn't count. And for a while, it looked like this issue was never going to get resolved. Following the court's decision, the Obama administration reissued the appropriate and necessary determination. The litigation was pending when the Trump administration took office. The Trump administration placed it in abeyance. It eventually repealed the Obama determination. The Trump administration made its own determination. It determined that the regulation of these pollutants was not appropriate and necessary. Litigation for that was pending. When the Biden administration took office, the Biden administration put it in abeyance. Eventually, the Biden administration promulgated the finding that the regulation of these pollutants was appropriate and necessary. And a lot was riding on this because at the same time, the Biden administration was strengthening the substantive standards that applied to these hazardous plants, and those were very controversial and were challenged and have now become like the focus of executive order activity as well. What was interesting to me is that I watched the calendar, and 60 days went by from the time the EPA administrator signed the rule and from the time it was published in the Federal Register, and nobody challenged it. So even though there was a lot at stake, and I actually think that the fact that the analytical work done was extremely careful, and a lot of time was spent explaining what the benefits were, and I mean, part of the problem was that some of these benefits couldn't be quantified and monetized, but they were actually very significant, and EPA did a very good job explaining the robustness of those benefits. I have the strong sense that that made a difference for why that rule was never challenged. Again, just one example. Maybe it's not representative, but I like it, so I'll end there. Thank you very much.